Hi friends, in this video log we will be discussing the recent raging case about the personal penalties levied on certain officials of a shipping line. This case pertains to 4 employees of Maersk India Shipping Line: Shantanu Sanjay Hundekari, Vikas Agarwal, Yogesh Agarwal and Mamta Gupta. They were represented by the stalwart Mr. Harish Salve in the Bombay High Court, and recently the High Court has quashed the show cause notice. Now, what are the details of this case? I'll not go into the exact case against the shipping line because that is another issue, and the court has also not dealt with that issue. In addition, DGGI Ahmedabad had also levied certain penalties on these 4 officials of the shipping line company. Now, these penalties were levied under section 122(1)(a) of the GST law, which provides for certain penalties. The amount of penalty is what brought this case into limelight. The penalty was 3,731 crores on these 4 persons. Now, Shantanu is a senior tax operations manager with the shipping line. Vikas is an area managing director, and Yogesh is a manager, as well as Mamta Gupta is area finance manager. All these 4 seems to have gone to DGGI during the investigation phase and recorded certain statements, which were relied upon by the DGGI Ahmedabad while issuing the show cause notice. Now, when the demand was being issued, they also levied penalty against these 4, and these 4 have gone to the Bombay High Court. The High Court, while quashing the show cause notice, has ruled that the show cause notice is illegal and stands vitiated by patent non-application of mind. These are very strong words that the court has used against the department. The penalty under section 121(a) can be invoked only towards a taxable person and not towards a person who is not even registered. These 4 were obviously not registered under GST law. The shipping line was, but the penalty was against these 4. So the court said 122(1)(a) cannot be imposed on individual person who is not registered. DGGI alleged that the transactions which were under demand were done at the instance of these 4. The court said that it was not true. There was no material brought to the court which proved that these 4 had instigated these transactions. And also there was no material on record that said that they have benefited out of these transactions. These 4 individuals were personally not benefited. So the court then quashed the show cause notice. Further, going ahead, the DGGI has also applied section 137, which is a penal provision, and the court, while ruling, said that this provision can also be not applied in this show cause notice. Why? Because the demand cum show cause notice under which 137 was imposed was issued under section 74, and you all know that 74 is a provision under which only determination of tax takes place. It is not a penal provision as such. First, the determination takes place and there is a financial penalty in that. Whereas section 137 is a penal provision liable to prosecution. Now, the court said the show cause notice is not the document, is not the way to impose 137, and hence 137 was also quashed. To end this, I would like to read one para number 33 out of this 48-page judgment. I'll quote the judgment. The foregoing discussion would also lead us to conclude that it is highly unconscionable and disproportionate for the concerned officer of the revenue to demand from the petitioner an amount of rupees 3,731 crores, which in fact is clearly alleged to be the liability of Maersk, as the contents of the show cause notice itself would demonstrate. The petitioner would not be incorrect in contending that the purpose of issuing the show cause notice to the petitioner, who is merely an employee, was designed to threaten and pressurize the petitioner. Hope this one para becomes a guiding principle for the officers who are issuing such demand notices. The employees don't go to work to have these penalties levied on them. They go to work for their own livelihood. These bone-crushing penalties will lead to employees saying to their HR guys that we will never appear for anyone, any company with any tax authority. Tax laws are not for such things. We sincerely hope that the department takes learning from this judgment and takes an approach which does not alienate the corporate employees from attending these tax proceedings. Our message to the employees would also be that there is nothing to fear. The courts will come to their rescue if the department doesn't listen to it. So do not fear from attending these tax proceedings. I hope this video is helpful to you. Thank you.